everyone, and thank you for joining us for today's webinar. My name is Michaela Vrazdova, and I'm a senior attorney at Scott Legal. We are going to spend some time today talking about the National Interest Waiver green card applications. A few things I wanted to mention before we get started. So Scott Legal is a full-service immigration law firm, and we assist individuals and companies with various types of visas. We assist with family-based visas and green cards, employment-based visas and green cards. And our main specialty is assisting entrepreneurs and investors. And we regularly process a high number of NIW petitions. We will continue to have this webinar series, and we will have at least 2 webinars a month on different immigration topics. At the end of this webinar, we'll send you a few things. We'll send you a PowerPoint that goes over the NIW criteria. We'll send you an NIW visa guide, which is a comprehensive visa guide that again kind of like explains the NIW criteria in detail. We'll send you a link to where you can sign up for additional webinars we will have in the future. And also this webinar, which is being recorded, will be saved there. This webinar will also be available on our YouTube channel, and we encourage you to subscribe and hit the notification button as we regularly upload immigration videos. And we'll also send you a link where you can set up a consultation with one of our attorneys. So with regards to our panelists today, we are lucky to have Jie Huang, who is a senior attorney at Scott Legal, and she has a wealth of visa experience, and she has a lot of experience, particularly with processing the NIW petitions. And as I mentioned, my name is Michaela Vrazdova, and I will be the moderator of today's webinar. So finally, for any questions you have, please put them in the chat box or the Q&A box, and we will get to all of the questions. So why don't we get started, GA, and talk a little bit about the who can qualify for the NIW, what is NIW, and what are the criteria?
Yeah, thanks so much for the introduction, Michaela. Yeah, so happy to give a general introduction about the NIW. So what is an NIW? So it is short for National Interest Waiver, and it is a subset of the EB2 employment-based immigrant petition category. Okay, so immigrant petition means this is an application for a green card, U.S. permanent resident status. So similar to the EB1, which is an extraordinary ability green card category, the NIW category is special that it allows self-petitioning for a green card. So this means an applicant doesn't need to have a U.S. job offer. You don't need to have a U.S. employer that is willing to sponsor you. So the applicant can also avoid the time-consuming process of labor certification, which is the requirement to test the U.S. labor market before you can qualify for an employer-sponsored green card. But for the EB1 category, only a very small number of individuals in the world have reached the level of expertise that are required for qualification under that category. By contrast, the NIW is a bit more accessible to even applicants who are relatively at the beginning of their careers, as long as they can show that their work will advance the cutting edge of the industry or advance the interests of society in some way. And another advantage that the NIW has as compared to other green card options, with premium processing now available for all categories, NIW has become one of the fastest ways you can apply for a green card. You can receive a decision within 45 days, either a decision or an RFE. And once you respond to the RFE, the government will take another 45 days to get you a final decision.
So that's a great advantage of the NIW, that you can basically self-petition, right? Like you don't need like any company, like a person can just file a self-petition.
Exactly. That can be a great advantage for some people. Okay, so maybe then I'll go over what is the eligibility criteria for qualifying under the NIW green card petition category. So the first thing to note is that there is a threshold requirement to qualify under the EB2 category itself. And so for that, you need to be considered an advanced degree professional. And what that means is that you would either have a degree that is a master's degree or above, such as a PhD, for example. It can also be a JD, an MD, or an MBA, for example. It doesn't need to be an academic master's degree. Or you could also qualify if you have a bachelor's degree in your field and you have 5 years of progressive work experience following the receipt of your bachelor's degree. So the 5+ years of progressive work experience can serve as the equivalent of a master's degree or above. Now, there's another way you can meet the threshold for EB2 classification, which is through exceptional ability. And this does not need to show any sort of degree. So this can be an option if you do not have either a bachelor's or a master's. So for example, if you have 10 years of experience in your field, if you are a member of professional associations in your field, if you have related licenses required to practice in your field, if you can show significant recognition in your field, such as awards won or other forms of recognition, if you command a high salary than other people in your field, and as the totality of the evidence, if you can show that you are performing at a level significantly higher than what is ordinarily encountered in your field, you may also be able to qualify under the exceptional ability threshold. So assuming that then you qualify for the threshold criteria for the EB2 category itself, then you also need to show evidence meeting 3 matter of Danazar factors. And matter of Danazar is the case that set out this analysis of how you can qualify for the NIW. So I will go over these 3 factors. The first criteria is that your proposed endeavor, which is your planned work in the United States, must have substantial merit and national importance. And the case law says that you can demonstrate this merit in many different fields, including arts, sciences, business, culture, even philanthropy. And you need to also show, though, that the impact of your work will rise to the level of national importance. For example, if your work has nationwide or even global implications in a particular field, but for example, by introducing technological advances that will sort of push the envelope of how things are done in the industry as a whole, that is usually a very good way to show that your work will have national importance. Some of the examples that are cited in the case law for national importance are things like medical advances, improved manufacturing processes, for example, and other endeavors that have the potential to create significant positive economic impact. So the second prong for the matter of Danazar analysis is that the individual themselves must be well positioned to advance this endeavor, which is found to have substantial merit and national importance. By being well positioned, this means you would look at the individual themselves. So what is their educational background? What is the experience that they have that is related to the planned endeavor in the US? Have they a record of success already in similar related endeavors? For example, if you're proposing to do research in a particular field, let's say astrophysics, has the individual already published research in astrophysics before? And have they been cited many times by other independent researchers? Have they actually resulted in pushing the envelope in the field? Those are the questions that you would ask, and then those are the evidences that you would collect to show that you are indeed well positioned to do the work that you propose to do. So the third requirement is that on balance, it should be beneficial to the United States to waive the labor certification requirement. And for entrepreneurs in particular, there is a very strong argument we can use, which is that the labor certification requirement was really designed by Congress to protect the domestic labor supply in the United States. However, in the case of entrepreneurs, the entrepreneur is not taking away a job from a U.S. person. The entrepreneur is actually creating more jobs for U.S. people by developing their business, hiring U.S. workers, generating revenues, and also contributing to tax revenues as well. So if in the case of an entrepreneur who has already been working in the US in particular, we can certainly use all of these data as benefits that really positively weigh in favor of granting the national interest waiver in comparison to the benefits of saving one particular spot for a US worker.
Thanks, GA. And you mentioned that people can qualify through a bachelor's degree and 5 years of progressive work experience. So, can you explain the progressive work experience? Like, what is it? Like, is it kind of like any experience, or what does the progressive mean? And then, like, how do you usually what type of evidence do you need to submit to prove that, yes, you had these, 5 years of progressive work experience?
Yeah, it's a very important question. So progressive here means that the duties have been changing over time, and the duties have been changing to more senior level duties. So for example, if I start working at a law firm as a junior associate, then I would be promoted to senior associate, and then maybe I will be working as a partner after five years. So that kind of senior progression of duties, of responsibilities, of salary, those progressive changes are what we are looking for in terms of proving progressive work experience. If your experience has stayed the same over the 5 years that you've worked after you received your bachelor's, that would unfortunately not qualify as progressive work experience, as USCIS is looking for that change, gradual change in your duties. So how we would prove this is by employment confirmation letters. And this will be signed by the company's representative. So if you are no longer working there, you would need to contact them and get a letter from a representative of that company, even if you stop working there. And it will typically be on company letterhead that includes the company logo, the company address, and where the company representative can be contacted. So the formalities of such letters is also important because it really goes to credibility of your application. And another thing to emphasize is that the 5 years of experience must be after you receive the bachelor's degree. If the 5 years of experience was before you completed your bachelor's degree, that would not work to support this analysis.
And GA, what if someone, because many people probably have like a US bachelor's, US master's, but what if your degree is from like a foreign university? Like, do you need to get like an evaluation of that education?
Yes, that is a very good question. And the answer is yes. You will need to get a foreign equivalency, educational equivalency evaluation of your degree. There is a list of providers that in the internet that you can look for that does these evaluations for immigration purposes. So you can send your transcript, send in your diploma, and the relevant agency will submit a report or give you a report that we will include with your petition.
And you mentioned, GA, that you can also, meet the threshold requirement, if you show that you have exceptional ability. So is the exceptional ability for NIW kind of like the same standard as the EB1 extraordinary ability, or is it lower? Is it higher? And kind of like what's the difference?
Yeah, that is also a great question. So fortunately, exceptional ability is a lower standard than extraordinary ability for an EB1. And the language of what they're looking for is a degree of expertise significantly above that ordinarily encountered in the sciences, arts, or business. That is definitely different from the EB1 standard, which is that you need to rise to a level, to rise to the very, very top of your field, of your relevant field. So, for example, for EB1, for example, the awards and recognitions that they're looking for will really be the one that is the most prestigious in your field. But for exceptional ability, you can submit a wider variety of evidences to support that you are higher performing than others that are ordinarily encountered in the field.
Perfect. And can you give us an example of a national interest waiver applicant who kind of like met each of the requirements you mentioned in the beginning?
Yeah, certainly. So I can discuss one of the AAO cases, one of the fact patterns from an AAO case that is very interesting that came down, I think maybe 5 or 7 years ago. So in this case, the applicant was an entrepreneur, and the entrepreneur proposed to set up a small consulting firm. And this consulting firm would be focused on doing projects with relevant organizations for the purpose of improving veteran services and caring for wounded warriors. And in particular, and this goes to what the person's proposed endeavor was, this person submitted a business plan, which detailed his plans to coordinate organizations and projects to facilitate the reintegration of returning veterans and wounded warriors into U.S. productive society. And so in this business plan, this person included letters from prospective clients, and the business plan also included financials for his company. How would this company be managed? And so there was a lot of detail in this application about exactly how his work will improve program offerings that are currently available in the United States. So it was a proposal on how to innovate in how veteran services are given to really improve the quality of these services and really facilitate these veterans in finding productive jobs, for example, like linking them to employment opportunities, for example. And the partners that submitted these letters of intent included various leading philanthropic organizations in the US, included government entities and businesses. So there was a lot of interest in the industry already that he could show that was already interested in this plan. Similarly, this person submitted government reports, news articles, letters from senior officers active in the veterans field, describing what are the gaps in veterans care and how his work in particular can help fill these gaps. So looking at all of these evidences, the government was able to find that this work indeed has substantial merit and national importance. So that's the first prong. Now, moving on to the second prong, well positioned to advance the proposed endeavor. So this applicant in particular had a remarkable success record in past related endeavors that he has led in the UK, which was where he was from. And to evidence this person got letters from senior officials in the UK, government officials who had worked with him before. And it was really, the letters describe testimonials of his past projects. And for example, what the results of these projects were. One of the examples that was cited was that his work has connected the private sector and philanthropic sector in such a way, using his unique network to enable millions of dollars in charitable funding being connected to the right organizations in the US and UK, and how it changed veterans' lives through this process. So the detailed business plan, the detailed letters talking about his past projects that have already had such incredible impact on the ground was really the basis with which the government concluded that this person was indeed well positioned to engage in these plans that was found to have national importance. So the third prong then, on balance, it would be beneficial to the US to waive the labor certification requirement for this individual. Now, it is important to note that you need to already have passed prong 1 and prong 2 to even get to prong 3, okay? So now in this case, prong 1 was already met, prong 2 was met, so the government looked at prong 3, whether it would be on balance beneficial to exempt this person from the labor certification requirement and grant him an NIW to come to the US and do this work. So in this case, the government talked about how this person was an entrepreneur. So this person will be self-employed. So it will be actually impractical for him to get a green card through the traditional employer-sponsored categories. So basically, the NIW would be the only option for him available. Now, the record also talked about the outsized values that the positive values that would result from his work that would change the way veterans are served, which would have more benefits than just benefiting his immediate clients that he would be working with. It would result in societal change, which was found to have a broader impact than just his business and his self-interest. So finally, his unique track record in successfully leading those kinds of initiatives supported the government in finding that this person would bring such qualifications, unique qualifications, that even if other U.S. workers were available with the minimum qualifications, it would still be better to bring him in to uniquely advance this work.
Perfect. Very interesting. Gia, can you go a little bit over, like when entrepreneurs are, want to apply for the NIW, like, do they need to have an already established company, or can they apply through a startup? And let's say that they already have an established company, like what kind of things, like what does the government look at, like do they look at like how many employees the business has, like at the revenues, or what else do they look at?
Yeah, that is a very good question. And that is certainly a question that we get a lot from potential clients and our existing clients. So the answer is that both are possible. Both scenarios are possible. You do not already need to have an established company to qualify for an NIW. So that is not a requirement. It is certainly possible that you can propose to set up a new company once the NIW is approved. So it is different from the E2 context, where there is a real and operating requirement. For the NIW, the plans could be a little bit more prospective, and you do not have to already have an entity. You do not have to have those infrastructures set up yet. However, your proposed plans must be specific and probable. And so there is a language that it comes down in a lot of case law that denies the petitions, which is that, quote, and I quote, the NIW cannot be used to assist somebody to do a job search in the United States. So if you're proposing, what that means, if you're proposing just to come to the United States and look for jobs, that's certainly not going to be sufficient for being approved for an NIW. The government is looking for a project that already has a little bit of traction, interest. Even if you don't have the infrastructure all set up yet, it is very, very positive if you submit letters of intent from potential partners in the U.S. For example, if you have a company that you have but that you're negotiating a project with, you want to get a letter from that company, a representative from that company, or even a contract for those services, or even a letter of intent that can be a little bit less formal. But in any of those situations, having that objective proof that there is industry interest in your work can be very beneficial for your project. So I guess I could go over then maybe the pros and cons of applying with an established company versus applying for the NIW with a brand new startup. So let's then talk about the scenario where you already have an established company in the US. You have been maybe operating this company for a while. Maybe you are on an E2 visa. You have been developing this company. So the pros of applying for an NIW after you have a successful business track record is just that: existing hiring numbers, existing revenues, existing tax revenues that you've paid. All of these data can support the projection of more economic growth, more hiring in the future, more tax revenue contributions. And so you can use historical data to really project into the future and support the fact that your business will generate substantial positive economic impact as the NIW is looking for. Another very good advantage that having a business track record could have is if you have worked on high-profile projects. Let's say you are a developer of architectural innovative projects, and your product has been actually implemented in, let's say, the offices of Google. in California, for example. Like those things can really show that you are offering something that is at the cutting edge of the industry, which is evidenced by these high-profile entities taking an interest in your work. So these contracts, these high-profile big projects that you've done can really support your case by supporting that your future work will also have such impact, and that you are indeed offering something that is above and beyond what the ordinary service providers do in your industry. Now, with regards to cons, so the disadvantage of applying with an established company is that if your company has not been doing so well in the past, or if, let's say, your hiring numbers were low, let's say you were managing a company, a more smaller company with only 2 employees, let's say, then it could be a stretch if you have not seen that growth pattern in the past. Maybe it will be less persuasive if you try to extrapolate into the future into a larger scale growth and larger scale hiring numbers. That could be less persuasive. So that could be a disadvantage if you already have a company in the US, that you could be bound by the track record there. Now let's discuss the startup option, where you don't have any existing company, but you are proposing that you will come to the US and start up a new company. So the pros of this is that as long as the plan, your business plan, makes sense and is credible based on your experiences in education, there is no need to show a history of high performance with those revenues and hiring numbers. You can simply lead with your plan. But the disadvantage of this option is really that if you don't have much experience that is related to your proposed business endeavor, the proposal has the risk of sounding speculative, and this may not be enough to secure an approval. You will need to show otherwise where did you gain the relevant experiences that will really make you well positioned to advance your amazing business plans. So for example, if you're an engineer and you want to start up an engineering firm developing a certain technology, you may want to show a record of working at different employers, for example, in your past, where you have worked on relevant projects that has a connection to what you will be doing in the US. Even if you have not been leading a company before, even if you were just an employee, all of these experiences that you've gained in your career could come into play when you're supporting your proposal.
Perfect. Thank you, GA. And now let's talk a little bit more about kind of like the timeline, how long it takes, to potentially like get the green card through the NIW. So GA, can you go over like how long does it take the government to kind of like adjudicate the NIW petition, and then how long is it currently taking them to adjudicate the green card application?
Yeah, sure thing. So the first step in the NIW process is the I-140, which is the immigrant petition for alien worker. So now premium processing is available for the I-140 aspect for all applications, and you will get either a decision or an RFE in 45 calendar days. So if it is an approval, then that is the approval. Congratulations. If it is an RFE, then you would respond to the RFE. And the RFE is a request for evidence for those of you who don't know. That is when the USCIS defers adjudicating your case, but instead of adjudicating your case, they ask for more evidence because they are they want more information on a certain aspect of the case that they find concerning. So if you receive an RFE, once they receive our response to the RFE, they will take another 45 calendar days to come up with the final response. So without premium processing, then how long does it take? It would take approximately 1 year to get the initial decision or RFE. And once you respond to the RFE, the government will take typically around 2 to 3 months to get to a final decision.
And how much is the premium processing currently for the NIW?
$2,500 US. Yeah, so that is the first step, I-140. And the second step is once you have the approval, then you have two choices. You can either, and well, if you're not already in the US on a different status, you only have one choice, which is to go through your home country consulate to get your immigrant visa. And then once you get the immigrant visa, you land in the United States as a permanent resident. Now, if you are already in the United States on a different non-immigrant visa, you have the option to go through what is called the adjustment of status process, which is also called I-485 application. So how long does it take for the I-485 application? This really depends on the service center you are assigned to. It can take many years. So it is best to really budget the time accordingly. As an example, one center that I know in Maryland is taking over 30 months to come to a decision on the I-485. So that is a very long timeline there. However, one thing that I should note is that once you file the I-485, you are able to continue living in the US, and you can also apply for, while the application is pending, you can continue to stay in the US, and you can also apply for an employment authorization document, an EAD. And once you receive the EAD, you can work for any employer you want while you wait for the decision to come down on the I-485. So that is a huge relief for these applicants. With respect to consular processing, if you would rather process the immigrant visa through your home country consulate, you can certainly do that. It usually takes a little shorter. I've seen the process take somewhere around 4 to 6 months, in some cases over a year. So this really depends on which consulate you are going through. And it also depends on the workload at each consulate at each given time.
Perfect. And, let's say that someone, lives in the US on a non-immigrant status, such as, for example, I don't know, E2 or O1, and, the status is expiring and the person wants to file the I-140. Does kind of like filing of the I-140 like give you any status in the US? Like, can you stay in the US just because you filed the I-140? Or would that person like need to either like leave the US or file the adjustment of status kind of petition concurrently?
Yeah, that is a very important question. And actually, we've seen a lot of misconceptions around it. So the answer is that only filing the I-140 NIW application does not provide any status in the US. So just the fact that you filed an NIW, so I mean the first part of the NIW, the I-140, that does not give you any status. Now, once you file, though, the I-485, which is the second part of the green card process that I've explained before, and note that you can only file the I-485 once your priority date is current. And for this one, I would say definitely schedule a consultation to really go about understanding this because it can quite be a little bit of a complicated area. But the upshot is that the priority date has retrogressed. So in the past, usually the I-140 and the I-485 were able to be filed together concurrently, but recently that has not been the case. So there is a little bit of a delay before you will even be able to file the I-485. So that is kind of a complicated area, but the conclusion is once you file the I-485, yes, you do have the ability to continue staying in the US. And as I mentioned before, you could apply for an employment authorization document to even work in the US for any employer while the application is pending. And to clarify, if you're going through consular processing at the home country consulate, then it does not give you any ability to stay in the US. After it is filed, you will simply fly back to your home country, process the immigrant visa there, and then you would do your landing in the US at a later time.
Perfect. GA, can family members of the main NIW applicant also apply for a green card? And what family members are we talking about?
Sure thing. So your spouse and dependent children under 21 years and unmarried, they can join your application for a green card.
Perfect. From your experience, how long does it usually kind of like take to prepare, the evidence for NIW case, because the requirements, it sounds like you have to kind of like prove, all the different requirements. How long does it usually take?
Yeah, so you're definitely right that the NIW is a very paper-heavy application. So in my experience, it takes on average around 90 days if you really focus on it. So what this entails is you would prepare the documents to present your endeavor, such as you would prepare a statement of proposed endeavor, which explains this. You would, if you're an entrepreneur, you would prepare a business plan to submit to the government. You would also work with experts. You would also prepare expert letters to back up this endeavor and really develop the narrative of what you have been doing, how you do things differently than others, and why your endeavor will have such outsized impacts to the economy that you argue. And this work would also include collecting records from your career that describe the impact of your past work that is relevant to your current project. So all of these document collections and adjustments can take some time. So I would say around 90 days if you focus on it. But many clients also do this on sort of an on and off manner. If they're, simultaneously working on their business, they could be a little, busier than if you were just doing the preparation as a full-time manner. So it is common for a lot of clients to be working on this for around 6 months. It is very common, especially if the applicant's profile needs more development. This can even take longer. So we do have a lot of cases that have been preparing for a long time until we get to the point where we're ready to submit.
And Gia, you mentioned expert letters. So can you go over a little bit, what are the expert letters, like how many usually we would want to submit with NIW petition, and then can the applicant kind of like reuse old expert letters, for example, from an O1 visa petition or kind of like other visa petitions?
Yeah, sure. I can definitely talk about the expert letters. They are a very important part of the NIW petition because the NIW category is very narrative driven. The examiner needs to understand exactly what you're trying to do and why your work will have those outsized impacts that the NIW requires. So I do not recommend reusing old expert letters, especially if it was for a different visa category. And the reason why is because the focus of those expert letters are different. So we'll take the O1 as an example. The O1 letters are really focused on the individual themselves. Like, I am famous in my industry, I am well known. So it's really about the individual's acclaim, like how they receive publicity for their work. Now, for the NIW, a very important part of that is not what you have done already, but it is also what you will do in the future and the impact that your future work will have. So the NIW's focus is a little different because the prospective endeavor needs to get as much attention as the individual's past accomplishments. So what we will end up doing is really work with the older drafts, but we will adjust it, help you adjust it so that it will be more targeted to the NIW context, and you will also want to get it re-signed because you don't want these signatures to be stale. Now, I guess I could also overview what content should really be in the expert letters, and I can talk about 3 different elements that we usually include in these expert letters. So the first would be the expert's own credentials. And as a rule of thumb, the expert that you ask for these letters should have impressive credentials at first glance. So, for example, if you have the CVs of these experts, they will typically be long, have a lot of awards in it, publications, lists. We use a lot of professors, many decades of experience. If you're an entrepreneur and if you're, getting a letter from one of your colleagues, you want to have them to be from those who are holding senior positions in a corporation, a leading corporation, in the C-suite, for example, and you would typically have a decades of experience that this expert can talk about, which will really boost the credibility of those experts' opinions. The second thing you want to include is several examples of past projects that you have done and the impact that those past projects have made in the past. And that is important because those examples are used to bolster your claim that your future work will have such outsized impacts. The third thing you want to include is discuss a little bit about why your work has national importance. And you want to be a little careful here. So for example, if you're working in the aerospace industry, you can't just talk about how aerospace industry is so important for the US, because that's talking about the industry as a whole. By contrast, what can you say about your own specific work? So what are you developing in the aerospace industry that will improve the way things are done in the aerospace industry as a whole? So that's kind of the argument that you want to develop through these expert letters. And the experts, because they have such experience in that industry, will be able to successfully support and really make it more credible that what you will be doing will result in such impacts.
And should the experts be like people the applicant like know personally, or should they be kind of just like independent, just kind of like experts in the field?
Yeah, so that is also a very common question that we get. And I would say the ideal is really having a mix of referees that actually know you and have worked with you before, but also experts who don't know you at all, but they know you through your work. So independent experts tend to be favored by USCIS as an example of the person's exceptional ability or the impact of their work, because USCIS sees those independent experts as more objective when they look at someone's credentials or someone's work. So we highly recommend including at least one or two independent experts. To the extent you can find them through your extended network, for example, like, an acquaintance of an acquaintance, for example, that someone who is active in the industry, and you can speak to that person can review your record and issue a letter that could really be powerful.
And how many expert letters in total we would want to submit at least?
I would say 4 to 6.
Okay.
Would be a good number.
And let's talk a little bit more about kind of like entrepreneurs applying for NIW, and then we can get to the Q&A because we have some questions.
Yeah, sure thing.
What can entrepreneurs do to kind of strengthen the NIW application? Do you have any tips?
Sure. I would have 3 tips here. So the first tip I would give to entrepreneurs is that generate evidence of how your work benefits not only your immediate clients, but also advances best practices in your field as a whole. And so the way that I would recommend you go about this is, for example, there are a few suggestions. You can, write academic research articles relating to your know-how and research and get them published in reputable journals. And even if you are not in an academic-oriented field, you can still make publications. You can be invited to industry podcasts and give your opinions, give your insights. And so you can really build your influence in the industry that way. You could also present as a speaker at industry conferences relating to your know-how. I would highly encourage entrepreneurs to make presentations about their work, really boost this public image. Appear in media interviews or have articles written about you or your work. There can be a variety of ways you can make this happen. And finally, if you have the opportunity, you can participate in government-funded projects that is relevant to your field, or if you can apply for and receive government grants for your work, that can also be a good boost to your profile. The second tip I would give is get a letter of support from a government agency. And it doesn't need to be the Senate. It doesn't need to be the Congress. It can be a local government agency that can really support your work. And you can even have the letter talk about the job creation and tax revenue benefits that your business has been generating in the local community. So if you get a letter of support from a city government, for example, regional government, state government, that can also work. If you are working in a particular area, such as, let's say, environmental sustainability, there are agencies that are dedicated to that work. So if you want to reach out to them and get a letter from those sub-agencies within the city government or the state government, that can also help. There are so many opportunities you can explore there. Now, the third tip I would give to entrepreneurs is what could be helpful is if you get a letter from an independent economist confirming your business plan numbers, that they are reasonable. Also, they can help you calculate the indirect induced job creation efforts, indirect and induced job creation impacts that can even go beyond the direct job creation that you are proposing. So for example, if you're proposing that your business will grow to support 20 jobs, the economist can use a formula to support that. Actually, if you combine the indirect and induced job creation impacts, it will be the equivalent of creating 80 jobs in the local economy. So that can really give some more additional numbers for the government to look at when they're looking at your case.
Perfect. Thank you so much, EA. So now let's get to the Q&A. We have quite a few questions. So
okay.
The first one is someone is asking, I have MBA and 6 years of experience in data field. Currently, I'm working as a machine learning engineer. Can I qualify for a National Interest Waiver application? I don't have any research or articles published.
Yeah, so MBA definitely qualifies for the advanced degree threshold. You have experience in data field and working as a machine learning engineer. So I would say, I would first ask if you have participated in any R&D projects in the past, and has those R&D projects been commercialized? Have you participated in developing any IP, for example, patents? That can also help a lot, even if you don't have any articles or research published. I think it really depends on what your track record is and what your proposed endeavor will be in the United States. And if you can show broader impact that will go beyond just benefiting your employer, yeah, certainly that is something you can explore.
Perfect. So the next question, and I think we already answered this one, is can you please inform the estimated timeline of the application from start to finish? So yeah, we mentioned that there is possible premium processing for the I-140 and then the green card itself. Yeah, that can take anywhere
several
from
years.
A couple of months until up to like several years. So the next question is, I have held an E2 visa since 1992, and I ran own my company in Texas, potentially looking to change status to permanent residency. Is this possible with NIW?
Yeah, so we do have many clients who transitioned from an E2 visa to an NIW, so that is certainly possible. It really depends on what you're doing with your business and what your proposed endeavor will be in terms of what are the things that you can offer that will impact the industry as a whole, as opposed to just benefiting your clients. And it really will also depend on the magnitude of the work, the business that you have been running. So how large would be your revenues now? How many employees do you have now, and how many more employees will you hire in the future? Will these be, rising to the level of substantial positive economic impact? So those are fact-specific questions, so we can definitely help you explore that. Just please feel free to schedule a consultation with us, and we will be happy to look at your case.
Perfect. So the next question is recommendation letter, progressive work experience. My employer, US company, sponsored my H-1B petition. How can I get recommendation letter without them knowing that I'm applying for NIW?
Okay, so I think you're trying to know,
like, I think like prove work experience, like the progressive work experience, but I think they want to like ask the US employer for the letter, but they don't want the employer to know that they are applying for the NIW.
That is definitely possible. You don't need to tell them why you need the letter. It doesn't need to be addressed to USCIS. It can be just addressed to whom it may concern. It just needs to talk about how your duties changed over the years. If you're trying to prove progressive experience, so for example, the letter can say this person worked from like 2016 to 2018, and the person's title was blah blah blah, and the person's duties were this and that. And if you have many different positions, then you don't need to show changes of your duties within one position. If your positions actually changed as you change jobs, then you can just have these 3 letters. for example, talking about these changes, but it really depends on your case facts. But to the upshot of this is, no, you don't need to tell them that you're applying for an NIW, and the letter doesn't need to mention anything about the NIW. Though for those progressive work experience, that's really confirmation of the employment letter. So it doesn't need to have any sort of detail about the proposed endeavor or well-positioned or other things.
Okay, perfect. So the next question is, I have completed my master's in MBA, MIS in the US, and have a bachelor's in physics from my home country. I work in IT and have 5 years of experience. I have valuable responsibilities and was awarded for one project in my current company, but I don't have any research papers or any significant awards. Do I qualify, and what will I need to prove for my case?
Yeah, so in this case, similar to the other example that we discussed, if you don't have research that you've published before, you will need to think of other ways you can prove that your work will have broader impacts than just benefits to your employer. This can be done in many different ways. If the projects that you've worked on resulted in a product that has been widely commercialized, you can, gather reports about that. It will really depend on what innovations you were helping to bring to market, right? And so if you can really prove that what you've been doing has been, pushing the edge of how things are done in the industry, there are many different ways you can substantiate that. But if the evidence is light, then it just makes for a weaker case. So that's also something you want to consider.
Perfect. So the next question is on balance. I think this is about the third requirement. How can a tech professional who has a US bachelor's and 5 years of experience and currently residing back in the home country, working as a tech professional with non-US consulting firm, how can he show that on a balance, like the third balancing requirement, and to show that the PERM process, the labor certification should be waived?
For that, then the argument will really depend on the strength on the first and second prongs, which is your proposed endeavor should have substantial merit and national importance, and second, you'll be well positioned to advance this endeavor. And so, for example, for the first prong, if you will be participating in work that will advance how things are done in the industry as a whole, so if you're working on a new technology that can really revolutionize the field, that is something you really want to emphasize, because a strong prong 1 will really be taken into consideration in the prong 3 analysis as well. So on prong 2, you really want to talk about what unique qualifications you bring that cannot be replaced by an ordinary worker with the same minimum qualifications, right? So that's the way you would argue for yourself in the third prong. So, for example, if you have particular skills in a very small niche in tech consulting that cannot be replaced by any other tech consultant that are in the field in some way, if you have particular expertise that really is unique to you, that you have seen success in before in the past, those are the things that you will emphasize to beat prong 3.
Perfect. So someone is asking if this recording will be shared. So yes, we'll send a link to the recording after the webinar. The next question is this an EB2 visa? Yeah, so the NIW is kind of like a subcategory of the EB2 visa. So yeah, it's a special category of the EB2 or the EB2 green card. Then the next question is, are there any cons to premium processing? Does it give impression of being in a hurry?
No, I'm not aware of any cons, and all of the premium processing cases we've done have been approved, so I would say no.
Perfect. So the next question is, for people wanting to start a new business, as I am, and as mentioned, the need to show support from clients or suppliers, I have found is the SCORE organization, which is a national government business mentoring organization. It's been around 60 years. I'm currently working with 2 mentors. If new application has business mentors in the US, would this help the application?
Mentors, I don't think would help very much. I think what we're really looking for is interest in the industry. That is in the form of potential collaborators, potential clients. Mentors, I don't think would really be relevant here.
Okay, thanks, GA. So someone is asking for the green card petition, what if my child is now under the age of 21, but will be 21 after the petition is filed?
Yeah, I think there is a way to lock the child's age from the Child Status Protection Act, but it is very complicated. So definitely schedule a consultation so that we can really look at the dates and how they line up.
Perfect. The next question is, how should the recommendation letters be addressed? So yeah, we already talked about that. You can just, address it to USCIS, but you can also just address it like to whom it may concern, and that's completely fine.
Exactly.
So the next question is there a pre-check that is undertaken to see if I would have a high chance in getting an NIW approval? I'm currently on an E2 and have a business in the US.
Yeah, so yeah, what we can do then is please reach out to us and we will send you a NIW retainer. And what we will do is then the first step of that process, we will send you an introduction questionnaire, and then you would fill out the information relating to your proposed endeavor, or what you have been doing in the past, and things like that. And we will look at your introduction questionnaire and we will do an initial evaluation. And usually we don't spend too much time on it, just maybe several hours, and we will schedule a call with you. We will go over these options, but we will be using some of the retainer to it. So if you end up not wanting to go forward, then we will refund the rest of the retainer you paid. So there is no problem there. So the way to do that is really to start a case with us, and we will the first step we will do is the evaluation. So please reach out to us.
Perfect. And someone is asking if we would help with creating the proposed endeavor.
Yeah, we will help you strategize for sure. Yes. So the client themselves will be writing the proposed endeavor, but we will certainly talk to the client and discuss what are their ideas, and we will help you narrow down your ideas.
Perfect. And for the expert letters, someone is asking if the experts have to be based in the US.
No, they do not. And I have seen approvals where all of the experts were from a foreign country. However, it is helpful to have an experts be based in the US, because they can really talk about the prospective impacts to the US industry as a whole, as opposed to a foreign expert who may not be as familiar with what the needs and interests of the US industry is.
Perfect. The next question is, how far back in the past can we reference speaker presentations and media input?
So I would include everything. There is no time limitations on proving your influence in the industry. It would be favorable if you have continued to stay abreast of the industry developments and you have stayed at the cutting edge leading up to the day of the application. But there is no real time limit on how far we can go back to gather these kinds of evidences.
Perfect. The next question is, I have a franchise business. We are relocating from Canada to the US. I have certifications in Canada and Florida. We are working with a lawyer at this time to apply for an E2 visa. Would an NIW be an option? Yeah,
so assuming that there is limited new innovations or developments to the industry that's going on, I would say probably develop the business first and then reach out to us for the NIW to see if there is any argument there.
Perfect. The next question is, how important are citations? Can NIW be approved with low publication citations?
Yes, we have had approvals with 0 citations, and that is because the person has just not authored any papers. But there are many different ways you can prove industry influence. And one great way, I think, is to do industry presentations. So there are alternative ways you can prove industry influence, sorry. So I wouldn't be discouraged just just for the fact that you don't have any citations.
Perfect. And so the next question is, what about adjusting status from H-1B to NIW? Is this possible? My employer is considering sponsoring me through the regular, I think, the PERM process, but I'm wondering if NIW would be faster.
The NIW would be faster. And it is also possible to work with the employer to act as the petitioning entity for the NIW process. So certainly get in touch with us. We will look at your case and be able to give you advice.
Perfect. The next question is, what happens if you leave the US after your initial filing? Can you follow up in your country? So yeah, I think we went over this. So
yes.
If you file the petition as a consular processing, you can leave the US and it can still be approved. And once it's approved, you would just schedule an interview at your consulate in your home country.
Exactly.
And the next question is, I'm a foreign trained attorney with 40 years of experience and with MBA. I'm still planning to take LLM in the US. Is the MBA sufficient for the requirements, or is it better to go through the LLM before applying? I got articles published in my field.
International law. So with respect to the threshold, the MBA is sufficient to meet it, but your MBA should be relevant to what you're trying to do. So if you are going to be a researcher in law, the MBA may not be directly related. So in that case, I would maybe do the LLM and then apply if your proposed endeavor is going to be on legal research. But if you're going to be a entrepreneur, then yeah, the MBA would be sufficient. Yeah.
Perfect. So next question is, I work for a defense company in India. Am I allowed to enter the US? I have a decade of aerospace experience. Yeah, so this is very kind of like specific question. So yeah, I would maybe recommend to set up kind of like a consultation and, to discuss like what visa options there would be to kind of like come to the US. The next question is, can we provide pay stubs for proof of work? So I think this is like to show the work experience. But yeah, as we mentioned, like, you would really want those kind of like detailed letters, kind of like going over your job duties and explaining the progressive work experience. So the pay stubs would by themselves would not be sufficient. Perfect. The next question is, can you have an NIW I-140 in progress while the PERM is being filed by your current US employer? I'm on H-1B right now. In case the NIW fails, I have the employee-based route to fall back on. Is that legal?
I would say yes. You can have multiple I-140s going on at the same time. Again, though, please reach out to us so that we will look at your case in more detail.
Perfect. Next question. I have a bachelor degree in business, also MBA. I have worked 20 years in senior management for global companies in Bangladesh. I have been in the US since 1 year running an E2 business, which is a household cleaning franchise. I know cleaning franchise business is not the best for NIW. Do you think I have any possibilities to qualify for an NIW? Yeah, so for kind of like complex scenarios like this, it just may be, because we cannot answer yes or no. So I would recommend to schedule consultations so we can go in detail, over your qualifications, experience, and then what the options would be. The next question is, do the expert letters need to be addressed to USCIS or mentioned? So we already answered that question. So no, you don't need to mention USCIS at all. Then some of these questions ask about our legal fees and payment plan. And so yeah, we'll just reach out to us because we'll be sending email, with all the materials to all the attendees. So just please reach out to us, and then we can send you our engagement letter that kind of like lists the fees and the whole process. The next question is, can you assist in getting expert letters in the US through your network for non-US resident?
So yeah, we don't really provide, connection services to experts, but what you can do is there are also experts who provide letters for a fee. And also what I've seen a lot of clients do is really capitalize on your network. You can, mine your LinkedIn networks, for example, to see if there's anyone who would be able to help you. Social media can be very powerful. So.
Perfect. And the last question, do you guys charge for a preliminary evaluation? So yeah, GI already went over this. And as we mentioned, if you have any questions about the fees, please feel free to email us. And yeah, I think those were all the questions. So thank you everyone for joining us. And thank you, GI, for the amazing presentation.
Thank you, Michaela. Bye,
Okay.
everyone.